Hi, welcome to this episode of the FFF podcast, Faith and Family First. I'm Jim Hochberg. Today we're going to talk about why I had to sue the state of Hawaii on September 22nd, 2023, over failure to follow the National Voters' Rights Act of 1993. So let's see what that's about. Well, hello, Eva.
Jim, I'm actually looking forward to this show today because the one thing I really appreciate about you is you definitely put your money where your mouth is. I mean, when you say to someone, this is a problem, I'm going to sue you, you actually do. You do not play, and I love that. So I'm curious, as you walk us through this very interesting case.
So if we were to go backwards about a year now, because the election was last November. In fact, it's a year. There were people in Hawaii that were challenging the elections department in the counties and also at the state office of elections over the voter lists. I don't know if you were familiar with that or not.
Actually, I was. You had sent me your actual case and then all of your exhibits, so I was able to look through all this.
But that's much more recent.
No, I know, but I mean, I didn't realize that this bridge was going to be made. You know what I mean?
Well, I didn't know it was.
Okay.
But what I was saying is that about a year ago, friends of mine and people in the news that I didn't know were really complaining about the elections office in the counties and the state not giving them access to the voter rolls, that they were concerned that certain people didn't win their elections and they wanted to double check and, that kind of stuff. And I thought, why would they cheat in Hawaii? There's no need to cheat.
There really isn't. I mean, if you have Democrat by your name, you will probably win. Well, I'm so sorry for those Republicans that are listening.
Why would the elections office need to rig voting for Democrats in Hawaii? It's not even close, ever, except for Linda Lingle.
Well, do they believe that it's not so much rigged to help the Democrats, but that it's rigged to stop the Republicans?
I don't know what they were thinking.
Okay.
But then later, in the summertime 2023, I was contacted by Public Interest Legal Foundation, which, if you think about it, the acronym is PILF, PILF, which is kind of cool. I like it. I use it on all my files.
I always claim that people are pilfering things.
Well, so the interesting thing, though, is if you were to look at the pleadings in court, I am an attorney for PILF, Public Interest Legal Foundation, but my co-counsel is Noel Johnson, Maureen Riordan, and Joe Nixon, who are lawyer employees of PILF.
Okay.
And so I have never done a case where my client was a public interest legal thing like Alliance Defending Freedom.
Right.
They're never the client.
Right.
We're always only the attorneys for HFF or whatever, right?
Right.
But because what Public Interest Legal Foundation, PILF, what they do is they're in Alexandria, Virginia. They're a Virginia-based charity, kind of like HFF. They seek to promote the integrity of elections nationwide through research, education, remedial programs, and litigation. So you might want to throw "and litigation" on the end of the purposes for HFF, hire an in-house lawyer, and you can be both the lawyers and the client. But anyway, so they regularly utilize the National Voter Rights Act, which has public disclosure requirements, to get access to voter records so that they can make sure of very interesting things. And I like this, and that's why I took the case. They are, because the National Voter Rights Act requires every state to maintain an electronic database of all the voting registrations for the public to access, not voters in the state, not residents in the state.
Not candidates.
Well, I mean, it includes
they can.
all of them, but it doesn't.
Can be.
You don't have that qualifier.
Right.
So what the foundation, what PILF does is they go state to state, they get the data, they check the data to make sure people aren't registered in multiple jurisdictions, whether counties in the same state or multi-state jurisdictional registrations, because we really want people voting once.
And they didn't start in Hawaii, right? I
No,
mean, they've already
they're in
done
Virginia.
this.
They've been doing this around. So
do you know how many other states they've already?
I think
that
6.
Yeah. So that's the point I'm trying to make, is that they're not just picking on Hawaii. This is what they do, right? They check the voting records.
Well, so they analyze programs and activities of state, local election officials in order to determine whether lawful efforts are being made to keep the voter rolls current and accurate.
And everybody should care about that.
Everybody should care about that. And they produce and disseminate reports, articles, blog and social media posts and newsletters to advance public education aspect of their mission. So I was very interested in Public Interest Legal Foundation when they asked me if I'd be willing to take the case, and they gave me the draft of the complaint. And I said yes. So we filed in September 22nd. We have an ongoing case right now. We attached to the complaint the correspondence back and forth, because what the National Voter Rights Act requires is that the state maintain an accurate and up-to-date voter list for all the voting that goes on in the state, right? So on April 6th, before they had contacted me, PILF wrote a letter to Elections Chief Scott Nago asking, under the National Voters' Rights Act, for a current and updated copy of the complete voter roll extract containing all the data fields provided to the requesters having government or election purposes. Because in Hawaii, our law says anybody can't have the voter list.
Right. And it's
only
actually
certain people can have
specific,
it. So they were citing that group and saying, under the National Voter Rights Act, we want this information even though we don't qualify.
Right.
So they didn't respond. So on May 8th, the voter services lady, Jamie Kataoka, sent an email saying, "Thank you for your email. For a list of registered voters, please contact the county elections division."
That was May 10th.
May 8th.
I got May 10th.
Well, they wrote back and said on May 8th. So
okay.
Any further related questions should be directed to the county elections division. So on May 8th, they responded again, according to the PILF letter on May 17th, saying, "Thank you for your response. To clarify, are county election divisions the only ones with access to the official list of registrants, or does your office also maintain a master file comprised of all county lists?" Ms. Kataoka did not respond to answer the question, but on May 10th, she responded saying, "Thank you for your email. As noted on our prior email, for a list of registered voters, please contact the county elections division. Likewise, any related questions can be directed to them." So I'm reading to you from the May 17th, 2023 letter after those emails.
Okay.
And so before I was hired, my client, their lawyers,
Yeah, they did.
They wrote a very good letter explaining why that is a failure to maintain and provide the statewide list as required by the National Voter Rights Act, and also to provide access to all the data under that same statute. And so then the state of Hawaii Office of Elections writes back to PILF on June 28th. But it took 6 weeks for the letter to get there, which is kind of interesting. And there's this 1, 2, 3, 4.
Now, this was an attorney that
5,
responds this time, right?
Yeah, 6, 7-page letter quoting verbatim huge pieces of HRS statutes on what's going on in Hawaii.
So an untrained eye like me, when I saw this, I was impressed. I said,
"It looks like a big letter."
It looks like they're responding to all of the the things that were brought up, right? And that's what it looked like to me. Okay, I'm here. You quoted all of this, and now we're coming back with Hawaii revised statutes. This is what it says.
And so he says, finally, we do not interpret the federal law as impacting the voter registration information. In fact, we would point out that the specific language discussing how its provisions, except for this one provision, have no effect on the other laws, including the National Voter Rights Act. And with the above in mind, we respectfully disagree with your interpretation of the law and refer you to the county clerks.
So that was the circular thing.
Now, the interesting thing is,
go back to the
PILF has already won this argument in 6 other states. So I guess my friend Aaron Schuleiner didn't know that.
They didn't look that up.
PILF, they're not braggers.
Aaron, I hope you did not ask AI
So
to do this research for
on
you.
August 22nd, and this other letter was June 28th, on August 22nd, my client writes back and says, we are in receipt of your office's response to our National Voter Rights Act violation notice. Although your letter is dated June 28th, we didn't receive it until August 17th. So it probably went through a bunch of drafts and they never changed the date, but they made it look like that. So the thing is, then at the end of the letter, PILF says, please declare whether our intended use as described herein qualifies under your statute so we can have the stuff or not. And in response, on September 1st, Mr. Schuleiner wrote, this is written in response to your letter dated August 22nd. As previously noted, we referred you to the county clerks. We have nothing to add to our letter dated June 28th. And that was it.
So does that, I'm not an attorney. So when you write in a letter, please declare, right? And they say, please declare this. And they don't. They don't. Yeah. So
what they're saying is, I dare you, sue me.
Oh, really? That's how that's interpreted, huh?
That's what we.
Well, that's what you did.
We did. And so,
yeah,
that description of PILF that I read it came right out of the lawsuit. That's when you file a lawsuit, you have to tell the court who your client is, and that is who we've told the court our client is. And then we went through and cited all of the Hawaii law that Mr. Schuleiner and the people in the elections office are referring to and relying on as to why they don't have to follow the national law.
Yeah, I think because our listeners, especially our listeners, they're gonna be like, so what is Hawaii's law that makes it so different that Scott Nago and his team are able to say this is the way we do it? I mean, what makes our law different?
So the federal law, it just says, every state must maintain a complete and accurate and up-to-date electronic database of all of its voter data.
Period. End game.
And make it available to the public.
To the public. So they don't have any criteria.
What Hawaii says is the counties are going to do it. We're not even going to have one, which Congress said the state has to. I would bet nobody in the hearings on passing that bill said, well, what about Hawaii? They only have 4 counties. Why don't we let them do it? But there is no county-only exception. It's a federal law which supersedes contrary laws in the states that regulate the same thing.
So if the state comes back now, because they don't want to go to court.
Wait a minute, though. Before you do that, that was one of the differences.
Okay.
Is the state of Hawaii does not claims it does not maintain a statewide list.
Go to the county.
The lists are by county, right, which is not a cross-county list. They're only internal county info.
Now, please explain to people, because you did go to the county, right? You did try to get
those letters to do that. They did. They actually came here and went to the county.
And they still did not get provided the information because they don't qualify.
The other thing that's different in the Hawaii statutes from the National Voter Rights Act is Hawaii statutes say, if you want to use the information for this, or this, we'll give you this information. And the national law says it's got to be comprehensive and available to the public. It's kind of like the concealed carry permit in Hawaii was If you can prove as an individual a special need to have a gun for self-defense outside the home, we'll give you a permit. And in 50 years, I think the chiefs of police on the islands in this state granted 20 or something. And that's why I sued. And that's why last year in November, I won an order from the federal court telling the state of Hawaii they can't do that because the Second Amendment doesn't permit it. So we sued, asking the court to make the state of Hawaii come in and explain why they're not in violation of the federal law, which they clearly are because they don't have a statewide database and they don't give the general public all the data. So did the point on that is that's why in that last letter my client asked, please declare whether our intended use qualifies under your dumb little limitations.
Well, see, that's what I was going to ask. So when they went to the counties to ask this information, I saw the letters. You gave me copies of the letters. They were clear of what their intent was. They were saying, this is what we want to do. Did the counties come back with written, like, you don't qualify?
No.
They just didn't provide the information.
I think it was by email, and they may have. I actually don't know because that was before I was involved, and we will deal with that stuff. I mean, it's a good question. I don't know. My guess is they emailed and said you can't have it because otherwise my client wouldn't be arguing over I'm the public. I can have it. Yeah,
and I guess that's why I got confused because your client, especially in their letters, even before you were there, were very clear. Here's what federal law says. Here's what we're requesting. I think, if I'm not mistaken, didn't they even say in there, they kind of knew that Hawaii's law said that, but they were asking anyway. They wanted them to clarify that this is what the law says, so you're not going to provide it.
Right. And the interesting thing is, the reason that they need a statewide database with all the data in it is that's the only way to compare state to state. Because it's a federally mandated database.
So what do you think is going to happen? So if it's obviously it's going to go to trial.
Well, what's probably going to happen is the state of Hawaii is going to file a motion to dismiss.
Of course.
Because they're going to cite all that stuff in their letter.
Right.
And it probably won't get dismissed because the federal law, when Congress passes a law, it applies to every state. Mm-hmm. And states can't enact contrary provisions under that same topic because federal law controls.
And the key word is contrary. So by putting all this criteria on there, that's contrary.
It's contrary, exactly.
Yeah.
And so after we respond to a motion to dismiss, and they may not, they may just answer and skip the motion to dismiss. But in my experience in the state of Hawaii, they almost always.
Or the legislature will pass some kind of law in the next coming session.
Well, and then what happens is we'll take their depositions, the people who are on these letters, and probably not Mr. Shoelaner because he's the attorney, but I think he's not a litigating attorney. So when the litigating attorney files the motion to dismiss and it's not Mr. Shoelaner, then we'll deal with taking his deposition, grilling him under oath with a court reporter there, creating a transcript of why he feels he doesn't have to comply with the law and make him explain in way more detail the things that he wrote in his letter, because his very long letter was mostly quoting statutes.
No, I was impressed as a non-attorney that it seemed to me that he was saying this is what Hawaii law is. You don't qualify. Go back to the county. But it's interesting. He said go back to the county, right?
Right.
But
if this was Texas and they have 350 counties.
Yeah.
Congress said each state has to maintain a comprehensive, accurate, and up-to-date list for the public.
Well, it makes sense.
Yeah. I mean, and the fact that we have 4 or 5 counties here doesn't change the law. I don't think anybody said anything about the small county states.
So what happens if the state loses, right? So let's just say it goes.
Well, let's walk through what we're asking for.
Okay.
So when you sue somebody, you have to put in the lawsuit what their bad conduct was. And we do those by count 1, count 2,
right.
count 3. So count 1 is that they're violating a section of the National Voter Rights Act by denying access to the data because they don't have a state database to give, and the counties are only giving it if you qualify under their little regulations.
So that was my question. Do you think that that's the bottom line? The bottom line is that they don't have this information, that they're hiding it?
The counties have it. The state says they don't. They don't make the counties give it to them, so they don't have it.
So the counties, if we
and
believe,
the counties only have their own.
Right.
So that's why the state needs to aggregate in one place.
Okay. So remember, I'm just a layperson, right? So you're telling me that if we believe that, right, at face value, that the state doesn't have it, that it's just in the hands of the counties. So Mr. Smith could be in Maui County, and Mr. Smith could also be on Oahu County, and we wouldn't know because they're not talking to each other.
If it's the same person or brothers?
No, same person.
Well, that's what my client spends its time assuring across the country that it's not true.
Right.
So because they won't give the information to my client, they can't check. And the fact that the counties are aggregating their independent info, not anybody else's, it's Congress said this is how we want it done, and Hawaii saying, we're doing it our own way. So count 2 is functional denial because of the lack of a complete list. So they're saying go to the counties and get the stuff. But as you pointed out, each county could have the same guy in it and nobody would know because they're not consolidation, right? So what the lawsuit tells the court is that the foundation, my client, intends to use the requested data for reasons that are not related to the purposes described in Hawaii law, research, analysis, law enforcement, education, and commentary. The foundation can't obtain the data unless it swears in oath on a relevant form that it will only use the data for the approved purposes. By conditioning the foundation's federal right to inspect voter list maintenance records on their sworn agreement to abide by impermissible state law restrictions, Hawaii functionally denies the foundation access to the data. Hawaii's policy in this regard violates and conflicts with federal law. The Constitution has a provision that federal law supersedes, it's supreme to state law on the same topic that's contrary to each other. It's called the Supremacy Clause. So count 3 is unlawful restrictions because of these limitations. And so the requirement under the law that they give notice of the violation and the injury, that's one of those letters said, this is your notice of violating the law and our injury. That had to happen to qualify under the law to file the lawsuit.
So when you're doing the discovery, are you going to find out, is it possible that you're going to find out who has requested and received this information?
Sure. And how they've responded.
Yeah.
Because I know that a bunch of my friends were being very frustrated at the end of last year with the same problem. Not necessarily under the National Voter Rights Act. I didn't talk to them about that.
So what's going to happen if you find out that people that were accessing this didn't qualify on those criteria? So in other words, they were giving it to some people.
We'll find out. We'll see.
Well, interesting. Okay.
So then the last part of a lawsuit is called the prayer for relief. Sorry, Mitch, that's what it's called. Prayer for relief. He sued Calvary Chapel, Central Oahu, and One Love and a bunch of Foursquare churches, and his lawsuit had a prayer for relief. I love it. Anyway, yes. So in this case, the prayer for relief is saying, Judge, because they did this stuff, we would like the court to declare as a judgment that the State of Hawaii Office of Elections is in violation of the National Voter Rights Act, particular Section 8I, by refusing to allow the foundation to inspect and copy the records, declaring in a judgment that Section 8I of the National Voter Rights Act preempts and supersedes any requirement or restriction in Hawaii law, ordering the defendants to produce to the foundation the statewide voter registration data described in Hawaii law and permanently prohibiting the defendant, State of Hawaii Office of Election, from denying requests to inspect similar data in the future. And finally, ordering, this is my favorite one, you know what it is.
Go. Yes, Jim, go.
Ordering the State of Hawaii Department of Elections Office to pay foundations reasonable attorney fees and costs, including litigation expenses and costs, pursuant to federal law 52 U.S.C. Section 20510C.
I'm sorry, I had flashbacks to when you told the legislature, do not pass this bill. This was the one that was going to make the Pregnancy Resource Centers post. And you said, because I will sue you. You sued them. And I remember so much that hearing for the money to be released.
Yeah, that's when you sue the state of Hawaii, it's very interesting. When you sue the state of Hawaii and you either settle and they pay your fees or you get a judgment and they pay your attorney's fees, the state can't write the check if it's more than $5,000, and it's never $5,000. The legislature has to produce, and they do every year, the state legislature has a bill to pay all the legal fees to all the lawyers in all the cases that they have to pay the fees in. And so it goes to hearings and they, nobody really testifies. I've never heard a testimony against the bill, but it's fun to be in the hearing room for another bill in the same committee, and the attorney generals come up and they describe how much it is, and it's like 280,000, million, 500,000, whatever, right? And it's really fun when my firm is one of those people that get paid.
Yeah, well, I think they know now that when Jim Hochberg says, I'm going to sue you, that you kind of follow through, which was how we started the show today, that you made it clear that. So the point of the lawsuit is, if Hawaii is failing to abide by federal law that all the other states have to abide by to maintain accurate and current databases on their voter registrations and make it available to the general public, and they're not doing it, we got to make them do it. That's right. Well, so what happens? You win the case, and then what happens?
Well, if the court orders those things, my clients will get the database and they'll go through it and they'll do whatever analysis and research and reporting that it deserves. And, hopefully, if there are people like, okay, so I am going to start voting in 2028 in another state. I'm not going to also be registered here anymore.
Right.
But we know from the news some people do. So the foundation's goal is to call that stuff on a national level, state by state, make sure the same person isn't registered and voting in more than one place, because we're supposed to have one person, one vote.
Yes. Now, this organization, which is the
Public Interest Legal Foundation.
If you're interested, they are a 501c3. So if you're interested in making a donation to them, we'll put the link below for you to do that. And in the meantime, we want you to stay plugged in. We've got a couple of really good shows coming up by end of year. So make sure you come back and see what we're going to talk about next week. And like this video, share, subscribe, hit that notification button so you know every time we upload a new video. And we will see you all next week. Mahalo, everybody.
Aloha.